LLB subject summaries, Constitutional Law 1, meaning to preamble, that is meaning, historical background, kinds of constitutions, salient features of Indian Constitution, nature of Indian Constitution, and preamble of the Indian Constitution are the topics for discussion today in English language. All these topics were uploaded in 4 lectures long back. Today, as I am uploading summaries, subject summaries, once again I am uploading these 4 topics in English in a comprehensive way for the convenience of my student friends. In this class, I have to enlighten you the introduction of this constitution. Secondly, historical background of Indian Constitution, kinds of various kinds of constitutions, salient features of Indian Constitution, nature of Indian Constitution, and finally preamble of the Indian Constitution. As a matter of fact, all these topics are to be uploaded separately in separate lectures that I have done it long back. So I am now giving you the summary. So the entire corpus juris, that is a systematic classification of law, the most important branch of law is constitutional law. In corpus juris, that is systematic classification of law, I will upload one lecture for the convenience of the students friends, because many of the students do not know what is the general law, what is special law, what is natural law, what is substantive law, procedural law, what is that law having both substantive and procedural aspects, special law, special courts, all these aspects. I will take special lecture on corpus juris and allow you. So there are so many branches of law, namely public international law, public international law, constitutional law, administrative law. In other classification is substantive laws, procedural laws containing both substantive and procedural principles, various branches of public law, namely criminal law. All these aspects I will explain you in detail in a separate class. So there are, simply speaking, there are various branches of law. Some laws are codified, some laws are not codified. Codified means if a particular branch of law is said to be codified if it is systematically arranged and published in form of an enactment, like the Constitution of India or the Indian Penal Code, today Bharatiya Nyaya Sanhita 2023, Indian Evidence Laws, today Bharatiya Saksha Adhiniyam 2023, like this. So Transfer of Property Act 1882 means a particular branch of law is codified in the sense we can have section numbers, sections will be there, subsections will be there, clauses will be there, subclauses will be there. So most of the enactments, acts, legislations appear in form of sections, subsections, clauses, subclauses, etc. Whereas this Indian Constitution appears in form of articles, chapters, parts, etc. So don't think that the, tentatively speaking, sections and articles meaning is same. When there is slight difference, which I will let you know as and when opportunity comes, because the basis of Indian Constitution is the Government of India Act 1935. It was in the form of sections. It contained more than 300 sections. So that for the Indian Constitution, Government of India Act 1935 is basis. It was in sections. It is applicable to both India and Pakistan, even after Independence Act. But we got our Indian Constitution when once we have our Indian Constitution from with effect from 26 January 1950. This Government of India Act is no more applicable to India. However, it continued to apply in Pakistan, subject to subject to amendments through amendment acts of that particular country. So, dear friends, so the Constitution of India is of great importance. It is so generally almost all constitutions in the world are originated from Greek and Roman kingdoms. So the origin of constitution is from Greek and Roman is what we say. Among all branches of law, constitutional law is of great importance. So because any substantive law or procedural law or law passed by state legislatures by delegated legislation, local laws passed by local authorities should be in consonance with the constitutional law. So law passed by parliament should be according to constitutional law, laws passed by states according to law passed by parliament, and law passed by according to constitution. Even local laws also should be according to state law, parliament, union law and constitution. If any law, rule, provision is inconsistent, repugnant or in conflict to any provision of the constitution, it is declared void, invalid, illegal and unconstitutional. So Article 13, Clause 1 and Clause 2 of Indian Constitution speak about supremacy of the Indian Constitution. According to Article 13, Clause 1, whatever laws were passed before Indian Constitution came into force, that is 26 January 1950, so many legislations were passed. During British rule, 19 legislations were passed in during Third Law Commission. Subsequently, so many British enactments were passed. Whatever laws were passed by British Parliament before our Indian Constitution came into force must be according to provisions of the Indian Constitution only. That is, all the pre-constitutional laws must be according to the provisions of the Indian Constitution. If any provision in any law in as a whole, in partly or section, provision is not according to Indian Constitution, that is consistent with Indian Constitution, that pre-constitutional legislation was declared to be unconstitutional. Similarly, even after 1950, even after Constitution came into force, so many legislations are passed. Nearly more than 1,000 legislations were passed by British Parliament. Many innumerable number of legislations were passed by state legislatures. All these must be according to the provisions of the Constitution. That is the significance or greatness of the Constitution of India. So in India, the Constitution is the supreme law of the land. Supreme law of the land. So in corpus juris, public international law is there. In public international law is there. Private international law is there. Constitutional law is there. Administrative law is there. So in this connection, because at this time I want to tell you few seconds about public international law. Public international law or law of the states is a law with relating to various countries in the world. So here there is a world union or world organization called United Nations organizations, and 195 countries are the members of the United Nations, and two countries recognition is in pending, that is Vatican City, where the population is 600. There is a Palestine. So here, if any country wants to become the member of United Nations, the United Nations will give temporary recognition. That temporary membership is called de facto recognition. So when any country in the world wants to join as member of the United Nations, the fundamental requirement is it must help international peace and security. The purpose of United Nations is to establishment of international peace and security, and to promote friendly relations, and to meet with international obligations. So these are the fundamental ideal and slogan and objective of the formation of United Nations. Why I am telling this point, dear friends? Because so it is the duty of the United Nations to Security Council and see that there should not be any wars, there should not be any unnecessary death toll. So unfortunately we are this object of international organization is not being fructified, because the Russia-Ukraine war is being continued for years together. Now recently Israel, Iran with US intervention. It is very unfortunate to note these calamities through wars. Indirectly, the people at a global level will have to face the consequences of these wars, so that it is the why I am telling is it is the duty of the United Nations to control this unhappy situation and control it, but unfortunately they are not able to put down the situation and establish international peace and security. That is why I am telling you this particular point. So constitution is such a great item. In introduction, one more point is the word constitution is derived from the Latin word constituris. So constitution means rules, regulations, etc. What is constitution? Meaning I gave in depth, and I gave so many definitions of constitution and constitutional law in my previous lectures, dear friends. So constitution means, constitution is derived from the Latin word constitutro, constitutro. It means to establish, and a constitution is constitution is the text that contains rules and regulations relating to government and people, and it also defines various how the administration of justice should be, how the executive should be, how the legislature should be, what are the functions of these three organs, how what is the relationship between the state and government. All aspects are explained in this constitution law. So these rules to be applied and interpreted in courts of law, those rules those rules and regulations provision which are to be applied, interpreted in courts through judicial interpretation and judicial precedents, that is called constitutional law. constitutional law. So the constitution is a body of judicial interpretations, precedents and statutes that apply the principles of constitution. This is the meaning I have given in brief, dear friends. So now this is about introduction is over. Now the second point is historical background. How we got our Indian constitution. Today we are very happy, able to sleep pleasantly at home because we got independent, we got our Indian constitution. We celebrate Independence Day, we celebrate Republic Day. We celebrate Independence Day on 15th August. The Independence Act came into force, but we the people of India got liberated from Britishers. We got freed from the clutches of the British rule. That is Independence Day 1947. So the Republic means we framed our Indian Constitution. We are ruling our country according to our Constitution. That is the Republic Day. So some people innocently may ask, what is the difference between Independence Act and Independence Act and Republic Day, Independence Day and Republic Day. Suppose you book a flat in a building to be proposed to be constructed. The consumer will go to the builder and book the flat for some 50 lakhs or 60 lakhs. He pays some advance, and in course of after some time he will register the flat in his name. Though the flat is not ready, he will get the possession of the flat after 1 year, like that. So getting the flat registered in his name, we can say like that, like Independence Act. After possession is over, after interior work and everything is over, and after entering into the possession of when possession is given and house is when the purchaser enters into the house and starts living in that house, that is what is called that is equal to democracy. So through independence, or we became independent from British rule, and by democracy 26 January we could start ruling on our own. So from British rule to 1956, so many developments are there. So during British rule, there are more than 20 important constitutional developments, but I will enlighten you in brief about British rule, how we got independence from Britishers. I will explain. Dear friends, Britishers entered Indian soil in the year 1600 AD. Then the British in British there is a hereditary monarch. So dear friends, you please note that Great Britain is there, United Kingdom is there. Great Britain consists of three countries. One is England, Scotland, Wales. That is Britain or Great Britain. After in later this Ireland was acquired. Then these four countries put together United Kingdom. British have self-governance. British did not get any independence from anywhere. They were then America got independence from Britishers. So earlier more than 60 countries were under the control of British, and so many countries, India, Pakistan at a time, and when India got independence from independence from Britain, but India and Pakistan was got independent as two dominions, and in Eastern Pakistan, Bangladesh was there. Subsequently, Bangladesh got separated in 1971 through civil liberation war. So this is the key position. Similarly, Saudi Arabia, Qatar, Dubai, Emirates, Arabic Emirates, and South Africa, so many countries were under the British rule. Subsequently, they became independent. Earlier, America also was under British rule, and America got independence in the middle of the 18th century. Some 1760 sometime it got independent. If correct date, you can find out in Google. Now, this is the position of now here Britishers came to India in 1600 AD. They started ruling. The hereditary monarch, king or queen. King or queen was called crown. If the crown is a female, queen. If the crown is male, king. So then in 1600 the crown was Queen Elizabeth I. She issued a charter, just like law passed by parliament and signed by a president, like that. So the Queen Elizabeth I issued a charter of 1600 on 31st December 1600, and under that East India Company was established. It is headed by one governor and 24 court of directors. This East India Company, under the charter of 1600, started trading in India, started trading with exclusive trading rights. And first they acquired Madras. Madras was a small village at that time. Second, later they acquired, why I am telling you for your general knowledge. Later they acquired Surat. First, Madras was the first presidency, today Chennai. Surat was the second presidency. Thirdly, after acquiring Surat, Surat was in Surat is in Gujarat, near Ahmedabad. And now later they acquired 10,000 fishing village, Bombay. Bombay was very less income, more expenditure. It was treated as white elephant. Then Azimush Khan, the Subedar of Bengal, gave Bombay to King Charles I as a dowry in connection with his sister's marriage, Princess Catherine. So in course of time, Bombay developed as a presidential city. Then the headquarters of Surat transferred to Bombay, and when Bombay became independent presidency, there is no set quarters at Surat. Surat remained as ordinary town. Now, first presidency is said to be Madras, second presidency is said to be Bombay, and third presidency is said to be Calcutta. And Calcutta was acquired at that time. The Calcutta was a small village. There are two surrounding villages, Sultanati and Govindpur. On these three villages, the city of Calcutta was constructed. So these are, I am telling you, dear friend, in India there are innumerable number of cities and towns, but the earliest cities and towns are Calcutta, Bombay, Delhi, Madras, Bombay, Calcutta, not the so-called Delhi, Bombay, Delhi and other large cities in the country. The first and earliest cities are Madras, Bombay and Calcutta. For your information, I am telling you. As the time passed, though British came to India in 1600, their real strong ruling, the roots of their ruling deep rooted on Indian soil with their victory in the Battle of Plassey. In 1757, the Battle of Plassey was fought between Britishers and Britishers. British forces headed by Lord Clive, Commander-in-Chief of Armed Forces. From British side, Lord Clive was the Commander-in-Chief of Armed Forces from British side. From India, Bengal Nawab Siraj-ud-Dowla fought war took place, the battle took place between those two, and in that battle in 1757 Britishers got victory against Siraj-ud-Dowla, the Nawab of Bengal. Since then the British rule in India got strengthened. So here we got independence in 1947, we got republic in 1950. Normally taking, Britishers ruled India from 1600 to 1950, 350 years up to republic. Up to independence, 347 years. If you calculate from the victory and battle of Plassey, 190 years up to independence, 193 years up to republic, Britishers ruled. So Britishers ruled to 2 to 3.5 centuries. That is why we are addicted to English, we are addicted to British laws, English laws, and we are using so many terms in English only in all languages, in India. For example, road, train, like this, road to train like this. So many things we are using. Instead of local language, we are using ticket, we are using. That ticket is English word. What is it in Telugu? We cannot say, we can. So that is the position. So now, see, there are nearly 20 historical developments, constitutional development during British rules, and prominent among them we have to discuss. Today we are happy by getting independence and republic of our own. It is not, we could not get it free of cost. It is at the cost of struggles, sacrifices, and loss of lives of our great political leaders, people, and freedom fighters. The sacrifices, the struggles, sacrifices, and loss of lives of our people, our forefathers, we are enjoying the fruits of independence and republic. We as Indians must salute those great leaders for having blessed us, for having provided our independence and own democracy. This is for your information. There are several so there are significant events is there. So the Britishers ruling through East India Company trading rights, but in 1773 Regulating Act was passed. Before Regulating Act, Britishers could get any charter directly from Crown and ruled. After passing of the Regulating Act, the British Parliament was established. So when East India Company, that is Governor and Court of Directors, wanted to bring any policy matters, they could not go to Crown directly, and they should approach the Parliament. Parliament should pass law according to act passed by Parliament, then only they should. So before Regulating Act, East India Company could approach Crown directly. After Regulating Act, the Act of Parliament to regulate the affairs of East India Company is called Regulating Act. So after Regulating Act, if East India Company wanted to do anything, it should approach Parliament first. After clearance from Parliament, it could approach the Crown. Subsequently, after that, the Government of India so in those days when Britishers were ruling India, the British Indians were ill-treated, key positions were occupied by Britishers lowest positions were given by lowest jobs were given by Indians, but Indians were paid very less. Britishers were paid very high, and that type of ill treatment was there, and our Indians could no more tolerate our political leaders, freedom fighters, and people as a whole could no more tolerate, and they wanted to revolt against the Britishers and started anti-British campaign. You Britishers, you go back to your country. India is ours. They started started anti-British campaign for local self-government. In an attempt to have this local self-government till Constitution of India, some important events have taken place. In 1917, the August Declaration came. So then in 1917, the Secretary of State for India was Secretary of State Edwin Samuel Montagu. Edwin Samuel Montagu, he made a declaration in British Parliament, House of Commons, that so here the Britishers announced the intention of British government to give local self-government. That was the first declaration. This is what is called August Declaration. This was made in the year 1917. In 1917, Edwin Samuel Montagu, the Secretary of State for India, announced in his speech, announced in House of Commons. House of Commons means like our Rajya Sabha, like our Lok Sabha. House of Lords is like our Rajya Sabha. House of Commons is like our Lok Sabha. He announced in that House of Commons that the British, they announced the inclination of British to give local self-government to India. That is the first thing. And secondly, the Government of India Act 1919 was passed. The Government of India Act 1919 was the first milestone towards our agitation for local self-government. This for local the Government of India Act 1919 provided some features of our present constitution like bicameral legislation, state list, state subject, central subjects, like that. So this is a first milestone. Then bicameral legislation means lower house, upper house, Lok Sabha, Rajya Sabha, Legislative Assembly, Legislative Council, like that. Bicameral legislation. State subjects, central subjects was introduced for the first time. Today, according to Indian Constitution, Schedule 7, it contains union list, state list, and concurrent list. What are the subjects contained in union list? The central government can pass law. What are the subjects in state list? The state government can pass laws. What are the subjects in concurrent list? Both center and state can pass law. In the event of conflict, normally central legislation will prevail. In times of when as and when the harmony has to be maintained, the state legislation has to be given priority, keeping in view the public good, then the state law may prevail, but normally union law would prevail. This concept of central list, state list is incorporated for the first time there. Concurrent list was not there. In new Indian Constitution only the concurrent list is added under list Schedule 7 of the Indian Constitution. The Government of India 1919 is second. Next, second one is thereafter Simon Commission. So here in 1927, the British Parliament, sent Simon Commission. Simon was the leader of the business parliament in House of Commons. He was asked to go to India and look into the matter. Simon, along with 8 members, all were Englishmen. They went to India to speak to Indian leaders regarding this self independence issue, self government. But all the members are Englishmen. Our Indians opposed them. Simon go back in Mumbai. So that is there. Then that is the significance of Simon Commission. The purpose of sending Simon Commission in 1927 is to negotiate with the Indian leaders with regard to handing over India to Indians, handing over Indian soil to Indian and to Britishers to go back. But it was not. Thereafter, Government of India Act 1935 was passed. The Government of India Act 1935 is the second milestone towards our local self-government. In Government of India Act 1935 was a big legislation. It contained 324 sections. So Government of India Act was old constitution. Before when Government of India Act was there 1935, it was treated as a constitution. The sections were treated as a constitutional provision. They were applied to joint India and Pakistan. Pakistan. So in that particular distribution of powers is there, central autonomy is there, states provincial autonomy, states autonomy is there. Supreme Court provision was made under section 2200 for establishment of federal court was there. In those days there was no apex court. All appeals of High Court of Bombay, Delhi, Bombay, Madras, Calcutta, all the appeals were going to Privy Council located in London in those days. That is why under section 200 of Government of India Act, All India Services, so many provisions. What are the provisions that Indian Constitution contains today were there in British legislation, that is Government of India Act. This Government of India Act was passed by the British Parliament. It contained so many provisions of the Constitution. Those provisions are taken into Indian Constitution today. Thereafter, next development is Cripps mission. Cripps mission. So here 1942 what happened was, in 1939 Second World War broke out. So Britishers alone could not face this Second World War. Then the British government felt that the cooperation of Indians is necessary to fight the Second World War. So that is why this British government sent Sir Stanford Cripps, leader of opposition, leader in House of Commons, Lok Sabha leader, Sir Stanford Cripps, he of three ministers, and he went to India to negotiate with the Indian leaders. They said, we are ready to give, please cooperate for survival from Second World War. After the war is over, in post-World War period, we will sit pleasantly, and we promise to give independence we promise to declare independent India, and all these things you have to elect your Constituent Assembly, elect your Constituent Assembly members, and make a constitution of your own, and all these things were discussed. So thereafter after that, in 1945 Labour Party came to power in England. The Labour Party which came to power in England was sympathetic and very cordial and liberal towards independence of India, but the Labour Party promised to give independence to Indian. To that effect, they sent the deputed cabinet mission of three members of the cabinet. Three ministers of cabinet were sent to India to discuss with so many aspects. We are going to give India. You have to create temporary constituent assembly, elect your leader, you draft the constitution of your own, that constitution of our own, till then you follow according to Government of India Act 1935. Then they, with some conditions, they have given this, and subsequently Lord Mountbatten plan was came into is a notable point. In Lord Mountbatten in the year 1947 February, the Prime Minister Clement Attlee in 1947, February 1947, Clement Attlee was the Prime Minister of UK, and UK he declared the inclination of Britishers to give local self-government, and in the meantime, that is in March 1947, that Clement Attlee announced formally the independence to Indian. Subsequently, 1947 March, Lord Mountbatten was appointed as the Governor General and Viceroy of India, and they initiated a plan called transfer of power, and that they told the Indian leaders to come forward to make the constitution of your own, and you have to constitute the government of your own. At that time, the Indian leaders, Muslim League leaders united, and they formed the government. And then Jawaharlal Nehru was appointed as the Prime Minister from Congress, and five ministers were appointed as ministers from Muslim League. Then with this temporary parliament and constituent assembly was elected. It is more than 296 members were elected, and some 296 members were elected. The Constituent Assembly is nothing but a temporary parliament. So the purpose of, because if anybody in only parliament is competent to make a constitution. Suppose the present constitution is to be abolished and new constitution is to be made, the parliament should do. So without anything, if the Indians want their constitution of their own, they should have the government. If they have government, they should have temporary government, they should have temporary parliament. That temporary government was constituted. Nehru was appointed as the Prime Minister, and 5 ministers from Muslim League, that is Pakistan preferably, were appointed as government, and under that the Constituent Assembly was elected. The Constituent Assembly was slated for more than 300 members, but 296 members were elected. Out of them, 211 belonged to Congress, 73 belonged to Muslim League, and posts remain vacant. That is why this Constituent Assembly was constituted. The purpose of Constituent Assembly, that is a temporary parliament, was elected. When once Indian Constitution, once we got our own Constitution, the old government will vanish, will be abolished, and Constituent Assembly also will be abolished. So this Constituent Assembly, when the Constituent Assembly is elected, and Dr. V.B. Rajendra Prasad was elected as the chairman of this Constituent Assembly. So many committees were constituted. Among them, the most important committee was drafting committee. The drafting committee, it contained 7 members. Out of 7 members, the first member, B.R. Ambedkar, was the chairman, and 6 members were M.N. Rao, Munshi, and others, 6 members. This Constituent Assembly drafting committee, the drafting committee headed by B.R. Ambedkar, Ambedkar chairman, 6 member. They strove hard for nearly 3 years. That is 2 years, 11 months, 18 days. They conducted 11 sessions for 165 days. So after that, completing that, they published the Constituent Assembly, and it was submitted to its president, and it was published. When once any act is to be completed, before it becomes law, it is referred to parliamentarians, judges of High Court, judges of Supreme Court, all the concerned people, and they receive any proposals, amendments. Like that, the Constituent Assembly is published to get recommendations, amendments from various bodies. So accordingly, lawyers, judges, parliamentarians, High Court, all it is kept open for suggestions. So accordingly, 7,635 suggestions or amendments were proposed, but they cannot take all into consideration, but they took into consideration 2,473 proposals they took into consideration and brought about changes, and ultimately submitted this Constituent Assembly. It was signed on 26th November. It is adopted on 26th November 1946, and it was signed by the President Rajendra Prasad. Now, thereafter, immediately some provisions came into force with effect from 26 November 1949, and ultimately the Constitution came into force on 26 January 1950. So all the provisions came into force with effect from 1950. This is the history of our Indian Constitution. Now coming to the next point, constitutions are various kinds. Number one is unitary, second one is federal, third one is rigid constitution, is flexible constitution is there. So unitary constitution means the constitution is the supreme any law of the land. So the government should function according to constitution. So unitary constitution, in unitary, if the country follows unitary constitution, central government will be there, states will be there, all powers are vested in central government, but states act as subordinates only. This type of constitution is unitary constitution. In Britain, the constitution is unitary. So central government is powerful, states act as subordinates to center. In other words, there is a strong center. In the second one is in a federal constitution like America, center will have supremacy, states also will have supremacy. And in unitary, only center is sovereign. But in federal constitution, center is sovereign, states are sovereign. So India has a federal feature. For example, central government is independent and sovereign, state governments are independent and sovereign. Whatever state governments do, center will not question except on exceptional cases. So states can rule their state independently, center can rule their country independently. Center do not interfere. Center would not interfere in state affairs normally, except in exceptional cases. That is why in India, the best example for federal constitution is America. Similarly, the best example for federal constitution is India. Now the question is, what is Indian Constitution? So India contains some federal features, contains some unitary features, but that is why Indian Constitution is called federal, quasi-federal. I will explain about this in independent topic, nature of Indian Constitution. Then I will tell you what are the federal features India has, what are the unitary features which India has. But since India is having both federal features and unitary features, and India is declared to be quasi-federal. Now, next constitution is rigid constitution, flexible constitution. Some countries constitutions are rigid, some countries constitutions are flexible. So, rigid constitution means any constitution came into force hundreds of years back. The socio-economic conditions, social, economic, political, cultural, all conditions at that time and today are entirely different. Due to, as time passed, due to changing conditions, laws need change. So, in order to change the provisions of laws and various enactments, some amendment acts are to be passed. To bring about changes in constitutional amendments, constitutional amendment acts are passed by the Indian Parliament. Similarly, if any law, it may be Contract Act or Criminal Law or Tax or Property Act, Company Law, whatever it may be, when it was passed, it was long back. Some time to time, the constitutional amendments are to be made. Consumer Protection Act, Motor Vehicles Act. For all legislations, amendments will be made depending upon the changing circumstances. That is why, so the constitution also needs some amendments, changes. For that purpose, the amendment acts are there, the constitution. So the procedure for amendment is very strict. That constitution is said to be rigid. If the procedure is very liberal, that constitution is said to be flexible. That constitution is said to be very flexible. So, the American constitution is very rigid. In America, there are only 7 articles, 27 amendments. But in India, the constitution changed so many times. So, in India, at the time of constitution, 395 articles. Today, 448 articles, but the number is 395 last number, but ABCDs are added by subsequent constitutional amendments. But in India, we have nearly 106 constitutional amendment acts. Now, 106 amendment act relating to women's reservation in Lok Sabha and assemblies, 33% reservation. It is passed. It will be implemented from next Lok Sabha assembly elections, as it is to be. It is assented by President, approved by Lok Sabha, Rajya Sabha, and it is referred to state legislatures for approval. This task will be over, and it will come into force in next elections. So that is it. So here, if amendment procedure is strict, in India has both. Some provisions are difficult to amend, some provisions require simple majority, some provisions require special majority, some provisions amendment require special majority of 2/3 members present and voting in Lok Sabha, Rajya Sabha. Thereafter, approval by the state legislatures, more than 50% state legislatures. So, India, in some provisions can be amended with a simple majority, by majority of 1 vote. It can be made law. A simple special majority, 2/3 majority of members present and voting in Lok Sabha, Rajya Sabha. And also, in addition to special majority, there is ratification. The bill will be sent to state legislatures for approval. More than half of the legislatures should give approval, then only it will be passed into law. So these are with this various kinds of constitutions is over. Next one is features of Indian Constitution. So, see, meaning, definition, this is features of Indian Constitution is a new topic. So, the question may be asked, what are the features of Indian Constitution? Question may be asked, you have to write. So, Indian Constitution, we have to speak 15 features. Number 1 is Indian Constitution is written constitution. In the Constitution of India is in the form of a big document. At the time Constitution, it is in written form. When Indian Constitution came into force, it contained 395 sections, 22 parts and 8 schedules. So some articles put together one chapter. Some chapters put together one part. Some parts to put together. Some parts to put together a constitution. Like that, some mandals or taluks put together one district. Few districts put together division. Few divisions put together state, few states and union and territories put together a country. Like that, Indian constitution originally at the time when it came into force on 26 January, it contained, it is in written form containing 395 articles, 22 parts and 8 schedules. So these all article, first article to 395, they are divided into 22 parts. It is okay. At the end of constitution last article, there are some schedules. Schedule means in so many subjects, some appendix like subject index, formats like that. So Indian constitution contains some schedules. Schedule 1. Schedule 1 contains how many states are there. It contains the list of states, list of union territories. Then second, what is the provisions relating to president. So different, I will tell in written in the course of time. At the time of constitution, Indian constitution contained 395 articles divided into 22 parts, and again in addition to these there are 8 schedules were attached. But today, as on today, March 2026, India has 448 articles. But serial number is up to 395, but ABCD's additional articles are there. Few articles are deleted, many articles are added. So that is why 5 plus 40, 53 articles are increased by constitutional amendment. There are 106 constitutional amendment. Out of 100 constitutional amendment, 53 articles have been added. When once the constitutional amendments are there, new parts are made, new articles are made. That is why the 395 articles became 448 articles. 22 parts became 25 parts because part 4A is added by constitutional amendment, that is fundamental duties. Like that, different for administrative tribunals also one more part is added. Like that, earlier 8 schedules, but now 12 schedules. 4 more schedules are added. For 9th schedule added for agrarian laws. So these topics I will let you know. Indeed, I explained in previous class. So Indian constitution is lengthiest in the world. Indian constitution is the lengthiest in the world. Indian constitution is lengthiest in the world in the sense it has 448 articles divided into 25 chapters and 12 schedules. And now India, we have 406 amendment acts are there, up to 130, there is up to 130 there are 130 amendment bill number 130 is there. So 106, suppose the bills are pending. Because in Indian Parliament, there are 275 bills are there. Whether bill is presented earlier or later, when once a bill is passed into law by approval in Lok Sabha, Rajya Sabha, and some 5 years bill is picked out and accepted today, it will get 107 name. So yesterday's bill is picked out and passed into law, it will get. So out of whatever bills are pending, there are 275 bills pending in the parliament, and whatever bill is picked out and sent to Lok Sabha, Rajya Sabha, presidential assent, passed into law and made gazette notification, then through the Constitutional Amendment Act, then Amendment Act number 1. Amendment Act means the bill is not pending, it passed into law. Like that, there are 106 amendment acts, but the bill number 130 is also there in pending. There are this bill number 1, the last bill, 275 bills are pending. There out of the latest bill is 130 bills are pending. 130 bills are pending. So the bill number constitution 130. So it was presented in August 2025. It makes a proposal for removal of ministers and chief ministers who are on commission of serious crime and underwent prison for over 1 month and above. So this is the proposal of this 130 bill. So the Indian constitution is written constitution. It is lengthiest constitution. American constitution, Switzerland constitution, Australian constitution, they are in right. But UK constitution is not in writing. The constitution of UK is not written constitution. It is based on, it is in UK, the parliament is supreme. The parliament is supreme. Whatever parliament says, it is final. Britain means 3 countries, Great Britain, UK means including Ireland. So the parliament of Britain is located at Westminster, and whatever UK parliament, House of Lords, House of Commons, headed by hereditary monarch, crown, whatever parliament says is everything is final. So Professor Dicey, an eminent English jurist, said what British parliament says, it is final. It is such a powerful, it can make anything and everything except woman a man and man a woman. So the conventions are code of honors. So the Bill of Rights is there. There are so many. In British, 1215 Magna Carta was signed by then King John on 15th June 1215. We are in 2026. In 1215, one charter, royal charter, was signed by King John 15, who was the real monarch for civil liberties. At that time, King John was an illiterate. In course of time, eventually it became a main law. That is Magna Carta. It is main source of British. Then Bill of Rights 1618. That is from in our fundamental rights are originated from that Bill of Rights. So precedents are there, parliamentary declarations are there, last judgments given by House of Lords to House of Commons. In UK, the House of Lords to House of Commons, though they are judicial bodies, they can do even judgments also, judicial powers also. So that is why whatever law was passed in any judgment, it is called judicial precedent. So that is why the rule in Rallens versus Fletcher, the rule in Brinsmead versus Harrison, the rule in Road versus Ford, the actio personalis mortis cum persona, so many rules were made. So these are the various sources. For example, in India, environmental law is not codified, but there are more than 200 laws. But Indian, there is only one comprehensive law in India for environmental to regulate the environmental degradation. But there are so many laws. Air Pollution Act is there, Water Pollution Act there, Wildlife Protection Act is there, Forest Act is there, Environmental Protection Act is there. Like that, so many acts are there. But though there are more than 200, but 14 enactments are main acts. We are following that. But still, there is no comprehensive law as a whole, like Indian Penal Code or Bharatiya Saksha Adhiniyam, Indian Evidence Act or the Bharatiya Saksha Adhiniyam, like this, Transfer of Property Act, Prevention of Corruption Act, like that. So this is in Indian Parliament, in Indian Constitution of India is not written, it is not in writing. It is, they are following Bill of Rights, Magna Carta, judicial precedents, traditions, all these things are taking. So in UK, Parliament is superior, supreme, Parliament is supreme. So that is why in the Constitution of India, there is no, the Constitution of India, the Constitution of UK is unwritten, but Indian Constitution is written. It has so many amendment acts. 130, the bill number 130 is pending in Lok Sabha, Lok Sabha, Rajya Sabha, and 275 bills are pending, and 106 act is passed. There are so many schedules are there. So many Indian constitution, apart from 448 acts, there are so many schedules. Schedule 1 contains states. Schedule 2 contains provisions relating to presidents, governors. In that schedule 1, schedule 2, ABCDs are there. A, presidential and governor provisions. B was repealed. C, relating to speakers, parliament and state assemblies. Then D, list, column D relates to the provisions relating to judges of High Court and Supreme Court. Column E relates to the provisions relating to controller and auditor and control and auditor general of India. That is the. So list 3 relates to oaths and affirmations. How President of India, governors, ministers and all, they have to take oath or affirmation. Oath means putting a hand on Bhagavad Gita or something, speaking a few words that I will abide by those things. That is oath. Affirmation means a declaration. The declaration is given in some affirmate. That is called affirmation. What is oath? What is affirmation? That is there in the proformas are there in list 3. So list 4 relates to administration of scheduled areas. There are all states are not highly civilized. Some states are backward. Some Mizoram and tribal areas are there. How the administration will be different. So list 4, list 3. List 4 relating to list 4 relates to allocation of seats in Rajya Sabha. Rajya Sabha, Lok Sabha elections are held every 5 years, but Rajya Sabha is not. It is a permanent body. The elections are made every 2 years. So 1/3 of the members will be retired and new members will be elected. And there are various sources of membership, and Rajya Sabha membership is 6 years. Every 2 years old members who completed 6 years will go out and new members will be added. So Rajya Sabha is Rajya Sabha. How the seats, how many Rajya Sabha seats are to be allotted, that rules are provided under list 4. List 5, administration of scheduled areas. Some tribal areas are there. How the administration. List 6, Assam, Mizoram special provisions are there. Meghalaya, Assam, Meghalaya, Tripura, Mizoram, those tribal areas. What are the special provision? List 7 contains 3 lists: union list, state list, central list. Union list contains some subjects. On those subjects only Parliament can pass laws, center can pass laws. In state list is there. Whatever subjects are there in state list, state government can pass law. Union concurrent list is there. On the subject, state can pass law, center can pass law. For example, police, central police is there, state police is there. Education, central institutions are there, state institutions are there. Like that is concurrent list. Then the eighth languages. How many languages are there? List 8. How many languages are there? In India, there are 22 languages are recognized as official languages. So that is 8. List 9 is the Constitutional Amendment Act only. The list line is added. So because 42 Amendment Act, Constitution 42 Amendment, what happened is, in India, population is increasing, towns are becoming overcrowded, and roads are to be widened, and new roads are to be constructed, existing roads are to be widened, new roads are to be constructed, railroads are to be constructed. So that for that purpose, some buildings are to be demolished, some private lands are to be acquired. So earlier, right to property right to property was given the status of fundamental right under Article 19(1)(f), and Article 31. So, the Constitution Amendment Act 42 in 1976, right to property was abolished as a fundamental right, and it became only legal right only, because if it is given if it is a fundamental right, if any property is acquired, they will go to court and get their property back. So the government cannot take up any welfare measures, government cannot construct new roads, new railroads, cannot widen the roads, the problem. So that is why the right to property, which was a fundamental right under Article 19(1)(f), was abolished. Article 31 was abolished, and a new Article 31(b) was added to Indian Constitution. Under that, some agrarian laws, any state government, if any state government wants to acquire any land, it can pass a law. Under that law, any private property can be acquired by the government. Whatever compensation is given by the government, that landowner should accept. So this more priority will be given if the owner of the land is a minority community, like a Christian community. Suppose the school land, Christian school land or minority school or college land is acquired, then the reasonable compensation is paid. For normal, whatever compensation is given by government, they have to take it to the best as far as possible. They try to give good compensation, but the compensation given by government is not according to market value, according to government value only they are giving. So coming to the point, Schedule 9, like that, like that, Schedule 10, 11, 12 different provisions are added in this. So the Constitution, Indian Constitution is features of Constitution. Number 1, written is over. Number lengthiest Constitution is lengthiest Constitution, written is over. And now we are discussing about the features of Indian Constitution. Features of written is over, lengthiest over. Next, parliamentary democracy, parliamentary form of government, and parliamentary democracy and cabinet form of government. These two provisions are borrowed from, we followed from UK, United Kingdom, because parliamentary form of democracy means the people have the right to vote. With the right of vote, the people will elect the people representatives. In Lok Sabha time, MPs they elect. In assembly time, MLAs they elect. These MPs will elect their Prime Minister, and these MLAs will elect their Chief Minister. So that is what is called parliamentary democracy. So the government gets power with the help of the people. So the voice of the people, the voice of the government is the choice of the people. So the power of the government is subject to the will of the people. Today, people may give power to one party. In next election, they may give power to another party, because the government must be according to the will of the people. The people decide the government with the right of vote. With the right of vote. This is what is called parliamentary democracy. And cabinet form of government. Cabinet form of government means, in presidential form of government, the president is ultimate head. In cabinet form of government, council of ministers headed by chief minister will be there in states. Council of ministers headed by prime minister will be there. Though chief ministers and chief minister is cabinet here, ministers and prime minister is cabinet there. This what all policy matters are taken by the cabinet headed by CM here, cabinet headed by prime minister there. But these are subject to ultimate approval or assent by governor at state level, president at central level. This is central level. So here president at central level. President at central level. president at the central. This is cabinet form of. So this cabinet is responsible for the parliament. The parliament, the parliament can question the act, but the Congress, that is the parliament in US, cannot question the president. President can take anything. So the parliamentary form of democracy and cabinet form of government, these two concepts are followed from UK, United Kingdom. Next, sovereign, USA, socialist, USSR, secular, no, democratic republic. Democratic republic means for France. Democratic Republic, France. So our Indian constitution is sovereign, socialist, secular, democratic republic. Sovereign means India is independently independent. India is not subordinate to any country in the world. There may be more powerful countries, but India is India. India is independently independent. It is not subordinate to anything. So our Indian, according to our constitution, India is a sovereign. Socialist. Socialist means the purpose of Indian constitution is to provide a socialistic pattern of economy. Means all goods, factors of production, goods and commodities should be made available at the cheaper rates. This is the socialistic pattern is borrowed from USSR. China also US socialistic economy. China socialist economy, USSR socialist economy, America, Canada, they are capitalist economy, but India is both mixed economy. Capitalistic some points, socialist some point. For example, private RTC buses are there, cheaper rates. Private buses are there, costly. Postal is there, cheaper rate. Courier is there, costly, private. A postal registered post is 22 rupees anywhere in India, but if they see same is in courier, it will be 100 and above. So that is why in India, Indian economy is India, Russia, China, socialistic, Canada, America, capitalistic, but India is mixed. That secular. Secular means in India, all religions are one and the same. The India has no religion of its own. India has national flag, tricolored national flag. India has a national bird, peacock. India has national animal, tiger. But India has no religion of its own. The word socialist and secular are added to Preamble of our Constitution under 42nd Amendment Act. Now, democratic republic. Democratic republic means in some countries like UK and some other countries, the hereditary monarch will be the ultimate head of the constitution. But India, the elected head, the ultimate constitutional head is elected by the people. So the president of India is elected. The president of India is elected. People elect the MLAs, MPs, but those people will elect a president. So indirectly, the president of India is elected by the people. So depending upon the population, the number of votes will be worked out. So here, in some countries, hereditary monarch is there, but in India, sovereign was democratic republic in the sense the elected representative will be there. The constitutional head is elected by this. In India, the president of India is elected by the people. Now, fundamental rights. The fundamental rights means fundamental rights, directive principles. So, in human life, there are some rights. For survival of a human being, some rights are there. Without these rights, the man's position will be animal existence. So that is why without some rights, a man cannot survive. So this type of human rights were identified. 30 human rights were identified by United Nations Organization in Universal Declaration of Human Rights 1948. So these rights were taken into account by many constitutions as their human rights. Now, the constitution makers, while incorporating these human rights in our Indian constitution strove hard, and they had made untiring efforts. What rights are on more priority? What rights are less priority? The rights of human rights of top priority are enlisted in fundamental rights and part 3 of the constitution from article 12 to 35. But the fundamental rights, human rights of less importance are enlisted in directive principles of state policy under part 4. Directive principles of state policy under part 4. So the fundamental rights part 3 is borrowed from the Bill of Rights 1689 from America. The directive principles of state policy under part 4, article 36 to 51 are borrowed from Constitution of Ireland, that is UK, United Kingdom, 4th state. So this is the position. So what is the fundamental right directive principles? I will give you some small example. Suppose a middle class man is there, his salary is very limited, some 20-25,000. With that salary he will pay house rent, monthly provisions, children's school fees, like this, uniform. These are most important. So if son demands motorbike, daughter demands scooty, wife demands necklace. So they are also important, but they are of second importance, second priority. So the items of great necessity, inherent, they are enlisted in fundamental right. The directive principles, the desires of human wants, human rights of second priority are enlisted in directive principles of state policy, and the states are asked to implement these directive principles. The constitution gave guidelines to union government and state government to implement them within 10 years of after the constitution, that is within 1960. Constitution came into force 1950-60. For example, article 45. According to Article 45, the state government must give free and compulsory education to the children up to 14 years of age. 14 years of age, up to 10th standard. That is there. If the state has funds, it will give. If the state doesn't have funds, it's the. So the article right to education was earlier was in a directive principle. In course of time, it became one of the items in Article 21, fundamental right. Subsequently, our right to education became independent fundamental right by constitutional amendment under Article 21A. So, what is luxury yesterday became necessity today. Earlier, Article 21 gave guarantee to life and liberty, but so many items are added to Article 21. How Article 21 was expanded from time to time, how many items are added? Right to life, Article 121 gave guarantee to life, liberty. Subsequently, right to work, right to privacy, right to education, right to legal aid, right to medical aid, right to die, pollution-free environment, so right to cremation, right to burial. So many items have been added to Article 21. So what were of second category necessities have become first category necessities. For example, earlier only rich people could afford to maintain car. Now almost all common men are able to can afford to maintain car. What was luxury yesterday became necessity today. So what was directive principle yesterday has became utmost necessity and is added in this thing. So that is why the basic structure items have been increased. Article 21 items have been increased, what I explained in detail in that class. So fundamental right, Article 13, Part 3 of Indian Constitution contains Article 12 to 35 fundamental rights, but Article 4 of Indian Constitution deal with directive principles of state policy, that is second category of human rights, second category, that is then next point is fundamental duties. How when the man is a citizen of India, he is demanding fundamental right, at the same time he has duty. According to Solomon, a distinguished jurist, rights and duties are correlative. When once you claim right? You must also have duty or obligation like that. So the citizens are required to do certain obligation through fundamental duties. Earlier there were 10 fundamental rights. In subsequent constitutional amendment, one more item, 11th fundamental duty, namely duty to sing Janaganamana, duty to salute national flag, unity, integrity. We must respect the our traditions, customs. If we must we get ready to join army. If in case of war, the army is not enough, the people are required to join army, the people must ready to join, like that. So many we must respect the culture, we must honor unity, dignity, the brotherhood should be maintained. So many fundamental duties, 11 fundamental duties are inserted in and as the fundamental duties under article 51A under part 4A of the Indian Constitution. So next one is Indian Constitution is federal and unitary. So Indian Constitution has some federal features, Indian Constitution has some unitary features. So Indian Constitution has federal and quasi-federal features. It is called quasi-federal. The details we will discuss in next topic. Now adult suffrage in India, irrespective of any age, everyone who has completed the age of 18 years is qualified to vote. And subject to age fulfillment 25 years or 30, 35 as the case may be, he can also contest. That right given to citizen is called fundamental right by adult suffrage. Adult suffrage or adult suffrage means right to vote. This topic is borrowed from New Zealand. So here next, independence of judiciary. Independence of judiciary is borrowed from USA. Independence of judiciary means the judges of High Court and Supreme Court are appointed in a special way, collegium headed by Prime Minister of India. Collegium, High Court judges, Supreme Court judges are appointed by the team of collegium, and Chief Justice of India and other senior judges. In state collegium also will be there, chief justice and two other judges. State collegium will recommend the candidates for appointment of High Court. It is referred to central collegium. Central collegium will confirm that, and then it will go to President of India through Prime Minister's office. Then only any person may be appointed as a High Court judge or Supreme Court judge. At the same time, the body which appointed cannot remove them so easily. When any High Court judge is to be removed or Supreme Court judge is to be removed, they are removed by impeachment vote. But two-third majority of members in Lok Sabha, Rajya Sabha, how bill is to be passed, the impeachment move of High Court judge or Supreme Court judge also has to be moved. So that is the security of tenure. So the independence of judiciary is one of the important thing. This is borrowed from USA. Next, judicial review. Judicial review means if the parliament, if the union cabinet headed by president takes any decision or parliament passed any law, it violates any fundamental rights. If any individual's right is affected, he can go to High Court or Supreme Court. But the High Court or Supreme Court, with the power of review under Article 226, 227 High Court, under Article 32, 136 Supreme Court can set aside the order of state government or central government, union parliament or state legislature. Such a great power is vested. That power is called judicial review power. This power is borrowed from USA. Next, separation of power. Doctrine of separation of power. Separation of power means Montesquieu, an eminent jurist, Montesquieu, a French jurist, tells that there are three authorities in any government: executive, legislature, judiciary. So the executive should discharge executive function, legislature should discharge legislative function, judiciary should discharge judicial functions. So executive should not enter into judicial function, judiciary should not enter, so they have to do it. So that means the Prime Minister should not enter into Prime Minister or Minister should not enter into the affairs of the judges. Similarly, Parliament should not enter into the affairs of the executive or judiciary. So executive must do executive function, legislature must do legislative function, that is law making function, judiciary must do judicial function. This rule is coined by Montesquieu, French jurist. America followed but failed. UK did not follow. India followed partially. So India followed the doctrine of separation of power is followed in India, but partially. But in times of impeachment of judges, Parliament will encroach, the legislature will encroach, and similarly the judiciary may encroach in if any president rule is unconstitutional, judiciary will encroach on executive action in emergency executive action, or if any parliament passes law, it is challenged as unconstitutional, judiciary can set aside. Judiciary can encroach executive action, legislative action. Legislature can encroach judiciary at the time of impeachment. So that is why in India the three organs of the government, executive, legislature and judiciary, though are independent, but they are not independently independent, but interdependently independent. So next one is rule of law. Rule of law, rule is rule for all. It is originated from UK. The rule of law means nobody, all are equal separately, equality before law and equal protection of law. Equality, Article 14 tells you, Article 14, 15, 16, 17, 18, so many articles are provided to establish equality. There is no any sex, race, religion. Without any discrimination, all citizens are treated alike. So this is equality. So even king also must abide by law. The law is nothing but the act of God. So everybody in the country, a state must obey law. So that is what is called rule of law. On rule of law, I have given independent lecture in administrative law. Last one is single citizenship. In America, double citizenship is there. Double citizenship in the sense, suppose the citizen is living in California, he will get citizenship of California of New York, state of New York, state of state citizenship he will have, central citizenship, American citizenship he will have. But in India and UK, single citizenship is only. So you are Indian, whether you belong to Tamil Nadu, Andhra, Telangana, Maharashtra, Bihar, Bengal, but you will not get Andhra citizenship or Telangana citizenship. You will get only Indian citizenship is there. So these are the 15 features of Indian Constitution. 15 features of the Indian Constitution. Now next one is features of nature of Indian Constitution is the next topic. Nature of Indian Constitution. Nature of Indian Constitution. There had been a great controversy as to the question whether Indian Constitution is federal or unitary. So here Indian Constitution has unitary features and federal features. That is why some features are borrowed from UK, some features are borrowed from America. That is why unitary features are there. Don't think that unitary features only UK is having. Some other countries are having. Federal features also, the unitary features and federal features, so many countries are having. But India, we have unitary features and federal features. Our constitution makers, which features is suitable to our particular purpose, they borrowed from various countries' constitutions and made some changes, brought about some changes so as to meet the requirement of our Indian constitution. So that is why Dr. Ambedkar ji say it is not improper to say to borrow from other constitutions, but we want ultimate objective is to uplift the ideals and goals enshrined in Indian constitution so as to ensure welfare state is the ultimate goal. For that purpose, we may borrow various principles from various constitution so as to ensure the best of our contribution through uplifting the ideals and goals and establishing welfare state is what he said. So now coming to the federal features, written constitution USC, supremacy of constitution India, distribution of powers, some powers are done by state, some powers are done by center. State list is there, central list is there, concurrent list is there. The powers are distributed by center and state. India, dual polity, central government is sovereign, state government is sovereign. In India also, central government is sovereign, state government is sovereign. Authority of courts, rigid procedure. America, the procedure is rigid, but in India, some provisions are, according to Indian constitution, some provisions are very rigid. Some provisions can be amended by simple majority, some provisions can be amended by special majority, some provisions can be special majority, some provisions can be amended by special majority plus ratification of states, like our Nari Shakti Vandan Adhiniyam bill which was passed. It is in the process of ratification by states. Now these are what are federal features US constitution is having, India is having, or the unitary features. Generally, basically speaking, during peace time, India is federal. So states are independent, center is independent. In emergency time, when proclamation of emergency is there, national emergency is there, the center will rule all the states. No state will have the power. Legislative, executive, financial, all powers of the states go to center. Or secondly, even president rule is there one particular state. That state will not be the state in which president rule is imposed. That is state emergency or failure of constitutional emergency, president rule or state emergency is imposed. All powers of the states, executive, legislative powers are taken over by the center. So that is there. That is emergency time. India acts as unitary state. But however, in peace time, India acts as federal, but states are independent, power center is independent. However, there are so many cases. India as a center is even peacetime also, center encroaches on state powers. Because one is a strong central. For example, taxes are collected. Laws, state laws, union list is there, state list is there, central list is there. In union list, subjects are more. State list, some centers are less. So union is passing more laws. India is having priority. State is making laws on their own. But in making these laws also, in some cases, the governor will forward it to the president. The president may or may not accept. Then some bills, the state government alone is not final in state level. It is sent to president. Governor will send certain bills to president for assent. If president will not approve that bill, that law will remain invalid. That is there. So center appoints governors. Governors are the agents of central government. Suppose the governor is center is one party, state is another party. These two parties are almost rival parties or opposite parties. The governor will create trouble to the states. There are so many instances, conflicts take place between state government and governor. So governor keeps pending so many bills without forwarding the same to the president. Even if it forwarded to president, governor will not send the bill back to state legislature. That problem is there. Some bills he will send to president. President may not accept, that is there. All India services. Union Public Service Commission is there. IAS officers, IEPS officers are appointed by the union. They are sent to states. These IAS, IPS officers work in various states, but the IAS, IPS officers are under the control of the central government, and they may not sometimes cooperate. Conflict take place between these IAS, IPS officers and the state government, that is there. So like this, these are the various, even though in emergency time it is almost 100% union government. If national emergency, India will be union constitution 100%. For state wise, it acts as union government, unitary during president role, and in other times also, in peace time also, because of these things, all India services, appointment of governors, funds, so taxes are collected by center, and for so many things states are depending upon the funds from the central government. The planning commissions will be there. The planning commission will recommend how much share should be given to states. It may recommend up to 30%. The states are not satisfied. State chief ministers express their grievance. Center is taking all our money by taxes, but they are not giving. If they request center for 1,000 crores, the center may sanction 200 crores or 300 crores. This type of problems are being repeated every time. So in the light of that, Indian Constitution contains federal features from US, unitary features from federal UK. That is why the Indian Constitution is described as quasi-federal, quasi-semi-federal. Last topic for discussion is the preamble of our constitution. What is the preamble of our constitution? In question may be asked on preamble. In this, what are the contents of preamble? What is the opening words of Indian Constitution? The opening words of Indian Constitution are contained in preamble. What is our constitution? What is the purpose of our constitution? What is the objectives of our constitution? What are the pillars of our constitution? What our preamble, what our constitution through preamble gives guarantee. So the preamble is a document in writing. The constitution guarantees the people of India in writing through a document called preamble. So it is a key to open the minds of constitution makers. The constitution makers contained in preamble various objectives of the constitution, how to establish cashless, classless, egalitarian society, how to ensure unity, integrity of nation, how to provide guarantee justice, liberty, equality and fraternity. All these things are there. So if you take any textbook, the author, there will be the opening page will be preface. In that preface, the author will reveal what is the importance of this textbook, what is the purpose of this textbook, what are the topics covered, how it is helpful to lawyers, how it is helpful to judges, how it is helpful to law student. All these things he will write. So how the author expresses the contents of book, purpose of book, utility of book in the preface, the constitution makers contained in preamble have written in preamble what is our constitution, what is the purpose of our constitution, what our constitution guarantees to our people, what are the ideals and goals to be achieved in our Indian constitution. All these aspects have been provided for your Preamble. So at the time of constitution some items were not there, but by 42nd amendment certain words, socialist, secure, integrity of nation, some words are added. But accordingly, as on present, the preamble of our constitution tells that we, the people of India, having solemnly resolved to constitute India into sovereign, socialist, secular, democratic republic, and to ensure all justice, liberty, equality, fraternity. So the Indian opening words say that our India, we the people of India, all Indians, there is no any other foreign element is the citizen. All Indians are the citizens of India. The Constitution guarantees to citizens of India. Some other guarantees or protections are given to non-citizens also. Some of the provisions of Indian Constitution are available to citizens. A few may be available to non-citizens also. But the Indian Constitution, all the provisions are available to the citizens. So the all provisions of the Constitution are available to India. We the people of India, that is only Bharat Indians, not any other countries, British or other. Having solemnly resolved to constitute India into sovereign, socialist, secular, democratic republic. These 4 items I told you: sovereign, what is socialist, what is secular, what is democratic republic. So having solemnly resolved to constitute India into sovereign, India is sovereign, India is socialist, India is secular, India is a democratic republic. All the points I explained in the beginning of the features of the constitution. And to secure all Indians, justice, liberty, equality, fraternity. Justice, liberty, equality, fraternity. These are the 4 pillars of the Indian Constitution. On these 4 pillars, the multi-storied building of the Constitution is built. That is 395 articles that day with Amendment Acts 448. So these the various flats, 448 flats. Some 4 or 5 flats may be called wings or parts. And the 12 schedules, there may be clubhouse may be there. Suppose we describe this as a society, apartment society, greater society. So these justice, liberty, equality, fraternity, 4 pillars. On that 4 pillars, the multi-storied building is established. The multi-storied building contains 448 rooms, 40 rooms. Apart from schedule is there. Some rooms may be categorized as something, some as a chapter, some wing may be treated as a part, and the schedule, permanent schedule. Schedule one area clubhouse, one area gym, one area playground, one area garden, one area temple, like this, school, super bazaar, like this. So how this can be considered Indian constitution can be compared as a greater society built on 4 pillars, multi-storied building with all facilities, 448 articles, 25 parts, 12 schedules. So justice. This justice means, you know what do you mean by justice? What type of justice? Social, economic, political. Social justice means through preamble. Preamble tells that our constitution guarantees every citizen, everybody, social, economic, political. So irrespective of caste, sex, race, religion, all are treated equally. All are allowed to temples. All are allowed to public tanks. All are allowed to public places. When you go to movie, your all categories of people, manager may seated in one seat, next seat may be given to peon. When accidentally manager and this seated side by side, the manager cannot say you are peon, you cannot sit beside me, is what he cannot say. So like this. So social justice in classroom, all categories of children are seated side by side. That is called social justice. But even today, the social justice is not maintained absolutely. There is a incidence of discrimination is there in so many places, is what we witness. Suppose a family or rich family appoint a driver. When they go to some long tour on the middle, they stop the vehicle, they go to hotel, all family members sit in one table, the driver will sit separately in another table. If they acknowledge him as family member, they can take him in same table, allow him in same table. That is the real justice. Here in rich families, some rich families, cook is there. What food is made by cook, all will eat, but they do not treat them equally in all circumstances. So here the social justice lag behind. This type of social justice was not there in olden days. Untouchability was there. This was abolished. Subsequent legislations also were passed, and so that is called justice social. Economic means equal pay for equal work. This is not in practice even in today in India. Even after our 1950, some 76 years elapsed, but till the economic justice is not there. Because if, for example, I tell you, in some private colleges, the principal may get some 10 to 15,000 unaided, 20, 10,000, 15, 20, 40, up to 50,000. In aided college, the same principal will get today 3 lakhs above and will get pension of 1.5 lakhs like that. But whereas in unaided college, he doesn't have any pension, he doesn't get anything. For example, we are seeing in bank ATMs, at the bank security guards. They are not the employees of, in so many places, they are not the employees of the bank. But they purchase those workers from some private contractor. So that private contractor for the private contractor will get some 15,000 like that. He will pay some 10,000 or 12,000 to that man. So if that security guard is appointed at bank entrance or this ATM, if he is appointed with the bank, he will ask increase salary tomorrow, he will ask scale, promotion, everything. Suppose he is the 100% employee of the bank, he is expected to get salary of 40 to 50,000. But if through private contractor, he gets around 10,000 rupees. This is similarly, this practice is there everywhere. In university faculties aided by UGC and state governments, the so-called doctorates of subjects are appointed not as on scale, they are appointed as hourly basis. If they get a scale, their salary will be, lecturer or assistant professor salary will be more than 1 lakh, but for hourly basis they get salary around 20,000, 25,000, 30,000. It is significant to say that in a university, state university run by UGC and state funds, the teachers were appointed as teaching assistants for a salary of 2,000. In course of time, the salary rose to 10,000. So the economic justice is there in the preamble slogan. This economic justice being outweighed in so many cases in India. So this is like a justice, economic and political. Political justice means every citizen in the country is qualified to vote and qualified to contest. The farmer is okay, but the lottery is not so easy. But anyone can go and vote. There is no problem, nobody will object, and everybody will request us to come and vote. But regarding contest, to contest as a MLA, MP, what is required, we are all expected to know. There is no need to tell. Unless one has a lot of riches, he won't be able to contest in the election. And even if any particular conscience is reserved to a particular community, that man has no financial stability to contest, some rich man will support him to contest in the election. So that is what we are witnessing in the regular life. So justice, liberty, that is justice political. So liberty of thought, expression, faith. Liberty of thought, Article 19 gives you full freedom to speak anything. Article 91A provides 6 freedoms. Right to speak, express, right to silence. Secondly, right to assembly, right of assembly. and right of association, right of movement, right to reside, right to take up any profession. All freedoms, six freedoms are provided under that. And Article 14 provides that Article 15, 16, 17, all these articles will provide various provision irrespective of sex. 19 provides this liberty of thought. आपका मन, what is there in your mind, you can speak. That is your Article 19(1)(a), subject to defamation. Assembly, you can assemble, subject to crime of unlawful assembly. So like this. Association, workers union, staff union, like this. Right to move, you can move anywhere in India within the country. Reside, you can move, you can reside and settle in anywhere in India, any state. So you can take up any profession. Article 19(1)(g). Article 19(1)(f), right to property was abolished. Okay, so these are the faith, belief. Whatever you can have, you can trust any, you can have, you can believe any religion, you can have, show faith in any religion, and you can worship any god of your choice. But you can be a Hindu, you can be a Muslim, you can be a Christian, you can be a Jew, you can be a Jain, or anything. So the type of relevant provisions are there provided under fundamental rights. Next, equality and fraternity. So all Indians must have brotherlyhood. Hindu, Muslim, bhai. Hindus, Muslims, Christians, all must move like brothers and sisters. There should not be any community conflicts, etc. To that effect, so many conscious provisions are provided. So lastly, the thing is, the preamble contains justice, liberty, equality, fraternity. Relevant provisions are there in Indian Constitution, and sovereign, social, secular, democratic. All these things are there. Now, the question is, preamble, when you see the constitution text document, first you find the preamble and all these points. Then Article 1 will start. So now the question is, the preamble also is part of constitution or not? So in Rebirvari case, the Supreme Court said preamble is separate, constitution is separate. The Parliament has no power under Article 368, maybe part 20. The Parliament under Article 368 has no power to amend the. A Parliament can pass any law. The Parliament of India is provided so many constitutional provisions to make law and bring about the amendments and make any laws. But all these things I explained in previous lectures. In Constitutional Law 2, you will have to discuss so many things. So here the question is, in Rebirvari case, Shajan Singh case, the Supreme Court said that principle preamble is separate, constitution is separate. Preamble means opening concepts. Constitution means Article 1 to Article 395 with additional sections of 448 articles. Parliament can amend any act, any provision in out of these 448 articles, but Constitution, Parliament cannot amend the contents of the preamble: sovereign, social, secular, democratic republic, justice, liberty, equality, of fraternity. So subsequently, the Supreme Court in case Ananda Bharati versus State of Kerala said that the preamble also, there can be no wrong to say that preamble is a part of the Constitution. The preamble can be treated as part of the Constitution, and when once preamble is treated as part of the Constitution, the preamble also can be amended. But the basic structure, basic feature of the Constitution cannot be amended, is what the Supreme Court said. So the Parliament can, Supreme Court in case Ananda Bharati case said, preamble also is a part of the Constitution. So when you can amend any article from first article number 1 to 395, including additional sections of 448, when you can amend, the preamble also can amend, provided the basic structure of the Constitution cannot be curtailed. So what is the basic structure? Earlier, a democratic form of government, judicial, some integrity of nation, some few items were uh, said to be a basic feature. In course of time, so many items have been added. Whatever items are added, justice, liberty, equality, fraternity, Article 14 added as basic structure, Article 21 added as basic structure. Just like in Article 21, Article 21 started giving guarantee, life, liberty. Subsequently, so many items have been added. Similarly, in basic structure, Kesavananda Bharati case, Supreme Court said the preamble also can be amended, but basic structure of the Constitution cannot be amended. Earlier, 2-3 parts of the basic parts of preamble were treated as basic structure. In course of time, each and every part was found to be basic structure. In one way, so preamble can be amended provided basic structure cannot be amended. So, according to Kesavananda Beri Kisajan Singh, preamble cannot be amended. According to Kesavananda Bharati, preamble can be amended, but basic structure cannot be cut at. But the almost all the topics of conscient of preamble appear to be basic feature. So indirectly or indirectly, the preamble may be part of the Constitution. It contains cannot be amended. This is the friend I have given comprehensively. You are I sincerely tell you, I am giving lengthy lectures because you can watch them 10 minutes, 15 minutes like that. Thank you very much for reaching my channel to 20,400. Some 5 to 10 will be added, then 400 will be over. And I once again request the student friends not to unsubscribe my channel after completion of your studies, after third year, final year, LLB. Keep it. If you keep my channel remain subscribed without unsubscribing, as and with, even though you watch or not, as and when my notification comes, I know that being my subscriber, you like me and you love me, so that once my notification appears, you feel happy. Raga Surya Rao sir is okay, healthy and active. You can have the feeling. So for this purpose, because my channel is something different, a new entrants will subscribe is after studies is over, the outgoing people will unsubscribe it. My channel, my notifications will be helpful to you. Not only LLB time, as an advocate you can learn so many things. While appearing for judicial service, district judge exam, a civil service, whatsoever exam you choose, you can make use of my channel. I am taking lot of efforts for your benefit. My only goal in my life, residual part of life, is to upload all the 35 subjects designed to judicial service, ADJ exam and law. Please note that whenever I upload any lecture, it is common to LLB, LLM, judicial service, assistant public prosecutor, that exams also. These videos can be utilized even for the candidate appearing for district judge also. Don't think that district judge is a high standard big people, because candidates appearing for civil judge will be able to have more time and more work. The candidates appearing for district exam may not have enough time to study, spare that much time also what the civil judge candidates is sparing. By virtue of their age and experience, they will be able to face the district judges examination. Please, thank you very much for your patient hearing. So don't feel my lecture lengthy. So I know though your students neglect regular life even to attend 1 or 2 hours classes, but in examinations they are constrained to attend the classes for 4 hours, 5 hours. What I witnessed in my teaching career, before examination, one day before examination, crowds of students used to come to me, used to sit for 4 hours and above to get the summary on all examination days of 28 subjects. With that experience only I am doing this. So with lot of experience and lot of preparation I am doing this work. Please utilize this. Thank you very much for your patient hearing.